rise. The judges of the New York State Court of Appeals. Ceremony will now begin. All please be seated.
I welcome you all to these Law Day ceremonies. I want to particularly welcome the Presiding Justice of the Appellate Division, 3rd Department, Presiding Justice Mahoney. And seated next to him is our distinguished Mayor, Mayor for Life, Thomas Whalen. Judge Gabrielli, a former judge of this court, has honored us with his presence, as has the Solicitor General, Peter Sherwood, and we welcome you here, Sherwood. We have the Judge Sides, the Deputy Administrative Judge, and Judge Weiss here, and Judge Corman, former presiding judge of the Court of Claims. And as the ceremonies go on, I'll see others of you, but all of you are welcome to this Law Day ceremony where we celebrate the generations of justice. And we're privileged at this time to have as our first speaker the Attorney General. The Governor is on your program as the first speaker, but the Governor is unable to be with us. I just received a telephone call for him. He's busy working on the budget, which gives neither Mr. Abrams nor myself great comfort. No, actually, I'm sure that the Governor is healing the wounds sought to be inflicted on the judicial branch, and I'm grateful for that. So that the first speaker will be someone who has joined us in the past and whose presence we always welcome in this chamber. A man of great vigor and a man of extraordinary competence who serves this state so well as our Attorney General, the Honorable Robert Abrams.
Thank you very much, Chief Judge Wachtler, distinguished judges of the Court of Appeals, President Yanas, other distinguished members of the judiciary. The theme of today's ceremonies should remind us all what the founding fathers of our republic saw clearly 2 centuries ago. The rule of law, if it is to endure, must respond to the changes in society that arrive with each new generation while adhering to core principles of liberty and equality. We must therefore take care to ensure that each of our citizens, young and old, black and white, has an equal opportunity to participate in our democratic institutions. Fortunately, the very structure of our national democracy was designed to be responsive to the changes in the social landscape that would come with each new generation. 200 years ago, at the creation of our republic, we were a nation of barely 5 million, squeezed onto a narrow strip of land, bordered by the Appalachians to the west and the Atlantic to the east. Visionaries that they were, the constitutional framers recognized that as our numbers would grow, our nation's boundaries would expand, and the allocation of political power would have to reflect those changes. To that end, the Constitution requires us to take account every 10 years of how many we are, where we live, what we look like, and how we lead our productive lives. I speak, of course, of the decennial census, whose 200th anniversary we now celebrate. At the beginning of each decade, the resources of the federal government are mobilized for the single largest national enterprise short of war, counting ourselves in the places where we reside. Article 1, Section 2 of the Constitution requires an actual enumeration of the people of the United States every 10 years. Reflect for a moment on the difficulties the framers faced when they grappled with the problem of allocating political power, not only among themselves, but also among generations to come. There was in 1787 almost no experience anywhere in the world with representative democracy. The country had only 10 years before cast off the shackles of colonial rule and had spent the interim years operating under Articles of Confederation that had proved unwieldy. When they met at the Constitutional Convention, the founders struggled with the conflicts inherent in the attempt to form a more perfect union between sovereign states of different sizes and different interests. Allocation of representative power equally to each state would give disproportionate power to the residents of those states with the smallest populations, but proportionate representation would allow the larger states to dominate the smaller. As we know, the Great Compromise resolved that conflict. It created a bicameral legislature in which states were equally represented in one house, while the residents of states are to be represented proportionately in the other. But there remained another great conflict: how to account for the millions of human beings who, by reason of legally imposed slavery, could have no role in the political or social life of the new nation, but whom the slave states insisted should be counted for purposes of representation in the new national legislature. Framers settled on the 3/5 solution, which counted each slave as 3/5 of a person. That abominable scheme would not be jettisoned except by means of war. The Second American Revolution, the Civil War, resulted in a constitutional mandate to enumerate the whole number of persons, the words ingrained in our Constitution. But it would take 100 years more before our nation began to breathe life into the promise of equal representation in the national and state legislatures. Only in our lifetimes did the Supreme Court of the United States take hold of the problem of unequal representation and insist that in the allocation of legislative seats among our citizens, one person's vote, as nearly as is practicable, be equal to another's. We are now in the middle of conducting the census for the 21st time since Thomas Jefferson first prepared to report the population of the United States to President Washington. At the federal level, the decennial census is used to apportion among states seats in the House of Representatives and votes in the Electoral College. It is also used for redistricting congressional seats within states and for redistricting many state and local elective offices. Billions of dollars in federal aid are allocated annually on the basis of census figures. They are essential for planning and providing government programs, for conducting academic and scientific research, for marketing goods and services, and a myriad of other purposes. The decennial census will crystallize for the entire decade the basic distribution of voting power and governmental resources throughout society. It is therefore a matter of critical importance that census data be as accurate as can be achieved. We are far from realizing that goal because the census is unfortunately seriously flawed. Recent newspaper accounts tell of the Census Bureau's failure to send questionnaires to all Americans and of the failure of our citizens to respond. But there is another, even more intractable and damaging problem. Every decennial census for which measurement is possible has undercounted blacks, Hispanics, and poor people much more severely than it has undercounted others. In 1980, the census accounted for more than 99% of white middle-class Americans, but only 94% of black residents. That differential undercount of between 5 and 6% was the same as it was in 1940, in 1950, in 1960, and in 1970. The undercount of Latinos is similar. We have, in effect, counted each black or brown resident less fully than a white resident. Those who are most severely undercounted are not spread evenly throughout the country. They are primarily concentrated in our large cities. In 1980, for example, when the estimated net national undercount was about 3 million people, nearly 500,000 residents of New York City were not enumerated. Because cities and the urban states in which they are located shoulder a disproportionate share of the national undercount, the residents of those cities and states lose their fair share of voting power. In the long run, that can mean a loss of freedom for us all, for the right to vote freely and to have that vote fairly counted is at the core of a democratic society. Other serious injuries result from the differential undercount. During the 1980s, the federal government allocated more than $37 billion annually through programs based in whole or part on the size of the population to be served. These funds support education, health care, public transportation, and other social services. Usually, the funds are intended to aid those most in need of assistance, including our very young, our elderly, and our urban poor. When the census disproportionately undercounts urban populations, it cheats those groups of the resources necessary to escape both poverty and deprivation. For 10 years, New York State and New York City, along with others, have pressed the federal government to correct this critical problem. In 1980, the state initiated a lawsuit against federal officials seeking to require them to correct the census so that it would include the citizens who, by the Census Bureau's own account, are missed. We established the important principle that the federal courts are empowered to require the federal government to ensure that the census is as accurate as practicable. That litigation also spurred the Census Bureau to make concerted efforts to find a means to correct the differential undercount. In 1987, professionals in the Census Bureau concluded that statistical methods can correct the differential undercount, and the Bureau began to implement plans to use those methods. The Commerce Department, though, which oversees the Bureau, overruled those plans. We have therefore turned once again to the federal court for relief. We are confident that the judiciary will vindicate the right that we all share to participate in our very important democracy. As we celebrate Law Day today, we would do well to remember that the security of our democratic institutions demands our constant vigilance. Until recent years, few among us recognized that the decennial public ceremony of counting ourselves can also be an instrument for systematically excluding our least fortunate citizens from the full share of our nation's bounty. We must take care, therefore, to guard against such threats to full equality if we are to secure to future generations the prosperity and freedom our country offers. As we meet today, that challenge hangs in the balance.
Thank you very much. You honor us with your presence, and we certainly appreciate your being here, Attorney General Abrams. We also have with us this afternoon the Commissioner of the Department of Transportation, Franklin White. We have representing the spectrum of the criminal justice system from beginning to end, Albany County, Saul Greenberg, and trial judges, Judges Harris and Lyons. And we have, of course, at the other end, the Chairman of the Division of Parole, Raymond Rodriguez. And again, I welcome all of you here. Our next speaker is the President of the New York State Bar Association. And Albany is doubly blessed, not only because he happens to have his office here as President, but also because he is from Albany. He has brought great distinction to this city and great distinction to our State Bar Association, John Yanas.
Chief Judge Wachtler, Associate Judges of the Court of Appeals, Attorney General Abrams, Presiding Justice Mahoney, Mayor Whalen, Judge Gabrielli, distinguished members of the legislature, bench and bar, and friends. It is certainly fitting on Law Day that we celebrate and reflect on America's heritage and freedoms. Yet this should also be a time to resolve to take action on problems confronting our justice system. Rather than engage in puffery about the profession of law, and I could go on for hours telling you about the good things so many lawyers do that no one is aware of, I will focus my remarks on a crisis of such overwhelming scope and complexity that it challenges the very concept of justice for all citizens. And that is the fight for juvenile justice and child welfare reform in this state. With this year's Law Day theme, Generations of Justice, it is my hope that future generations will look back favorably on this generation for its accomplishments in treating the challenging problems facing today's families, most particularly the children. Responding to that need is in no way simple. Changes must be made in almost every part of our family court system if it is to cope with the ever-increasing caseloads fraught with all of society's problems, most prominently the epidemic of drug cases. We need more and we need better paid judges. We need more support personnel, more court resources, more and more readily accessible social services, so integral to making the court's work effective. I was delighted to read in this morning's New York Times that an accord has been reached between the governor and the legislature to legislative leaders to create 32 new judgeships. I assume this action will provide some relief to our family courts, but obviously more still needs to be done. Statistics tell part of a chilling tale of statewide scope. Abuse and neglect cases in New York City family courts climbed 700% in the past 10 years. The courts outside New York City experienced a 162% increase. The New York Legal Aid Society, which represents 99% of the children who are the subjects of abuse and neglect matters, reported that last May, with the substantial cut in federal funding, attorneys were handling an average workload of 147 children's cases. Increases have also been recorded in other matters. For example, termination of parental rights cases grew 148%, and custody and visitation petitions rose 134% in New York City over the last 5 years. Over 50,000 children were in foster care as of mid-1989, an increase of 15,000 from the previous year. Juvenile crime is also on the rise, reaching 14,000 cases in New York City family courts last year, up an astounding 83% in just 3 years. At City Council hearings earlier this year, it was reported that only a few years ago, jostling, a misdemeanor, was the largest problem involving youth. Now it is second-degree robbery, a felony. When we examine the facts behind these numbers, we see how daunting the task really is for us. 2/3 of the abuse and neglect proceedings in New York family courts in 1988 involved allegations of drug abuse, approximately 3 times as many cases as seen in 1986. Correspondingly, the number of newborns testing positive for drugs more than tripled from 1,325 to over 5,000. The effects of drugs, notably crack, on the functioning of the family were vividly described by a panel of legal, medical, and social services experts at a recent program sponsored by our association's Committee on Juvenile Justice and Child Welfare. As a physician noted, the courts and social services agencies are combating a unique and an insidious problem. To the crack user, experiencing that feeling of high over and over again becomes the only thing that matters, resulting in the neglect of their own needs and those of their families. And the stark reality, if crack could be wiped from the face of the earth tomorrow, society and the courts would continue to struggle with its ravaging after effects for years to come in the problems experienced by youngsters who were born with the drug and bear its physical and emotional scars. Compound the situation with poverty and homelessness and the problems that go hand in hand: lack of medical care, malnutrition, being at high risk for disease, frustration, anger, and lack of control. Too often these children will find their way to family court as children neglected or abused by their parents or as delinquents. While these cases may enter family court as single-issue problems, the complexity of the situation often requires investigation of a maze of mitigating circumstances, the involvement of many family members, multiple court appearances, and considerable time, energy, and resources expended on an already strained judicial system. Judges describe the extra efforts needed when no parent appears for the proceedings, and when, upon investigation, no parent can be located. As found in a 1987 survey of foster care agencies, remained away from home because their parents have been unable to find adequate housing. As we plead with Governor Cuomo and the legislature for additional assistance for the courts, we must stress that each statistic translates into a name, a face, and so often shattered dreams. This was painfully illustrated in the faces of the children in the waiting room of the Brooklyn Family Courts building when I visited that court last summer. Waiting for hours and hours for their cases to be called, they were confined in an overcrowded room without air conditioning, without working water fountains, with broken down elevators, to say nothing of the filthy condition of the building itself. It was hardly an atmosphere that would engender any respect for the majesty of the law or our judicial system. I admire and I applaud our family court judges, court personnel, and the attorneys that labor so diligently under such trying circumstances. Despite our needs in so many parts of our family court system, society looks to the family court judges to make decisions every day concerning the survival of our families and children. The volume and complexity of these matters and the importance of the court's mission clearly demonstrates the need for additional judges and support personnel throughout this state. In recent years, various amendments to the Domestic Relations Law, Family Court Act, and Social Services Law have been enacted for the purpose of providing additional procedural safeguards for children and families. In many cases, these changes have necessitated additional filings, appearances, and work of the bench and the bar. The court must be provided with the resources to breathe life into these laws. Efforts must continue to seek improvement in the law guardian system of providing representation to children. Our Committee on Juvenile Justice and Child Welfare has long been involved in examining and developing recommendations on these procedures. We produced law guardian representation standards as a reference to help guide those involved in these matters. The need for an effective and efficient law guardian system is clear-cut. Determining what means should be instituted to achieve this objective is the challenge. Our association's executive committee authorized the establishment of a task force to coordinate the work with the appellate divisions to build on the work done to resolve these difficult issues. We look forward to the report and the recommendations of that task force. 28 years after its creation, the family court still struggles against the misconception that because of its social services component, it is somewhat a lesser tribunal than other courts. As Chief Judge Wachtler observed in his State of the Judiciary message, the first step in changing this perception is eliminating the inequity in family court judges' compensation. His proposal calls for equalizing pay among the judges of this court and raising it to the level of the Supreme Court. The additional steps are, of course, providing the necessary judges and personnel for the court to properly function. I stressed this in my testimony in support of the state judiciary budget, and this was a common view of those testifying at a hearing on the family court caseload crisis conducted earlier this year by our association's Committee on Juvenile Justice and Child Welfare and the Association of the Bar of the City of New York's Committees on Family Court and Family Law. It is well recognized that building up the court's resources is essential if we are to stem the tidal wave of cases. But the court cannot fight the battle alone. Members of the bench, bar, medical, social services, and other professions, government and community leaders, as well as the individuals who appear before the court, stress that this problem needs the cooperation and the coordination of all. Leadership in this effort comes from the very top of our profession. It is significant that later today, Judge Wachtler will be presented with the 4th Annual Howard A. Levine Award for Excellence in Juvenile Justice and Child Welfare for his outstanding work in the area of children in the law. To be effective, the court must be able to call upon a range of services and have these programs readily available. As many have noted, this would be also practicing preventive medicine. How many cases could be prevented from reaching family court if such services were accessible? Thank you. A New York City family court judge painted this picture of reality. A family court is limited because it's a court, the implementation of which depends on others. It cannot find housing. It cannot open up drug programs. It cannot, in and of itself, save the children. What better time than Law Day to redouble our individual and cooperative efforts to see to it that our family court has the resources necessary to do justice to our families. Our children and the generations that follow are depending on us. We cannot let them down. I sincerely appreciate the invitation from Judge Wachtler to address this very distinguished gathering of leaders of our state and this community. When you leave this magnificent courtroom today, please pledge to increase your personal commitment to help ease the plight of those less fortunate children of this generation. Perhaps it is still possible that future generations will admire our accomplishments. Thank you.
Thank you very much, President Yanas, for being with us today and for your very constructive remarks and for all you've done on behalf of the State Bar Association during this past year. This day's celebration, as you've been told, speaks of the generations of justice. And we're reminded that this year we celebrate something else very significant, not only to we Americans, but to we New Yorkers. And I'm speaking now of the 200th anniversary of the Bill of Rights. And as you all know, and we've discussed this before, that Bill of Rights came about as a result of New York's insistence during the ratification process. And one of the most important parts of the Bill of Rights, the Due Process Clause of the Fifth Amendment, really came into being by virtue of an early New York State statute, which was elevated into the Bill of Rights, really at the insistence and under the authorship of John Lansing, whose portrait hangs behind me on the wall and who served as a member of the predecessor of this court and also as mayor of the city of Albany. Due process of law. Now, due process is kind of an intimidating factor to many people. I see lawyers and have seen lawyers, as we all have, arguing cases in this court being somewhat intimidated by, not by us, heaven knows, but by the awesome aspect of arguing the law in a courtroom. Imagine such an experience, if you can, compounded by these factors. You are uneducated in law, perhaps uneducated beyond the 8th grade. At stake may be eviction from your apartment, your ability to pay for medical care, repossession of your furnishings, the public assistance needed to feed your children, or even your custody of those children. More than anything, you are poor. Paying for an attorney to help you face these problems is out of the questions. And the problems continue to become compounded. President Yanas spoke of what is happening now with the young people, with the generation coming along. We know today, for example, that there are 475,000 children of addicted parents in New York State. We know that there are 60,000 foster children in the city of New York and 20,000 more every year. We know that there are 12,000 crack cocaine babies born last year in the city of New York. We know that the problems of abuse and neglect are coming into the courts. We know that poor people in this state are faced with situations like I have just described 3 million times a year. And yet, in New York City alone, we find that where there are 400,000 new proceedings filed in the family court, resulting in over 275,000 dispositions, 90% of the landlords are represented by counsel, but only 10 to 15% of the tenants. 2 years ago, with this in mind, with this desperate need in mind, I appointed the Committee to Improve the Availability of Legal Services, chaired by Victor Marrero. The committee was charged with a formidable task: to report on the extent of unmet legal services on the civil side for the state's poor, to explore the scope and operation of legal services currently provided, and most importantly, to prepare a plan for action to increase the availability of services to the poor. The centerpiece, and by far the most controversial aspect of this committee's preliminary report, and as of yesterday its final report, was a proposal that all admitted attorneys actively practicing law in the state be required to perform 40 hours of free legal service to the poor every 2 years. Suddenly, everyone in the legal profession became very aware of this problem. As soon as the talk of mandatory legal services came a matter of discussion, the mail poured in, suggestions poured in. Many attorneys reminded me of the fact that many attorneys do, and they do, perform a great deal of pro bono services. And many attorneys, if not almost 99% of those who took the time to write to me, and on petitions and also various resolutions from bar associations, advised me that the lawyers should be given a chance to volunteer their services. They said that is the best way to provide pro bono services. And they said that this effort should be increased. There's nothing that clarifies the mind like the sight of the gallows, I guess. At any rate, virtually everyone who has joined the debate about mandatory pro bono agrees that the best way, and I agree as well, that the best way to provide legal services to the poor is to increase funding for legal services and other special programs, recognizing the fact that this is not only an obligation of lawyers, that this is a societal obligation. And although public funding may be the more efficient and most equitable answer, it is simply unrealistic to believe that sufficient amounts will be forthcoming in the near future. Indeed, we've seen sharp and severe cuts at the federal level, and we know the present fiscal straits of the state. Of all the responses to the committee's report, the most constructive alternative has been offered by the New York State Bar Association. Significantly, the State Bar Report and its subcommittee, chaired by Justin Vigdor, does not take issue with the Marrero Committee's conclusion concerning the scope of the problem, the need for more public funding and the obligation of lawyers to increase their pro bono efforts. The association promises to redouble its efforts to see that there is assistance brought for legal services in this area. But it asks that we not have mandatory pro bono at this time. State Bar Association says there should be a moratorium so that the volunteer efforts could be increased, can be monitored, and that there can be some period whereby we can see if mandatory pro bono can be avoided or at least postponed. I believe the State Bar Association should be given this opportunity. Voluntary service, as I said a moment ago, is obviously preferable to compulsory service in any endeavor. Clients will be better served by lawyers who stand by their side willingly. In addition, I'm not unmindful of the arguments that there would be an inevitable legal confrontation. I've heard the arguments. The Marrero Committee report, which was made public yesterday, addresses these arguments with respect to not only the philosophy, but the constitutional arguments against mandatory pro bono, taking property without just compensation, involuntary servitude, that it would affect equal protection of the law. I think that these questions can all be answered, and I think the answer gravitates towards saying that mandatory pro bono would be constitutional. However, there is no need at this time to face that confrontation. I would avoid or seek to avoid, as long as I can, that wasteful and divisive confrontation that would seem to be inevitable and to be precipitated by the mandatory plan. And so, again, I would hope that the State Bar can meet its promise to increase the voluntary service to the point where mandatory would not be necessary. But I must caution that the only way to guarantee that mandatory would not come into vogue and that this confrontation about which I spoke a moment ago would not be inevitable would be for the State Bar Association and all the bar associations and lawyers who are not affiliated with bar associations to succeed in their efforts to raise the level of voluntary pro bono service. Again, while mandatory service is not the ideal answer, sufficient service is no answer. I close, therefore, by voicing the pledge that the energy and momentum generated by the Marrero Committee's work will continue, and by cautioning all those who have similarly pledged to work for the success of an alternative plan that your work will be looked at carefully with full confidence that you will do your job well. Progress will be monitored by a committee to be established for that purpose. In this respect, I would note that the Interest on Lawyers Account program, IOLA, has granted, as of March 31st, 1990, $1 million to devise methods of training lawyers so that they can render this service and to monitor the voluntary pro bono program and later, if at all necessary, and I hope not, a mandatory program. The Marrero Committee report, in all of its aspects, with the exception of the mandatory component, will be the foundation upon which the voluntary program will be constructed. If the program is successful, it will serve as a model throughout this nation of what lawyers can do when it comes to rendering the service which they feel is necessary to represent the citizens, all the citizens of this state. If after 2 years, however, it does not meet the desperate need, I will propose to the Administrative Board of the courts and my colleagues on the Court of Appeals that a rule be promulgated mandating pro bono services for the poor as recommended by the Marrero Committee. As that committee noted, if we do not act decisively and effectively in the crisis, especially in light of the known dynamics of poverty, the legal needs of poor persons will accrue. The human hardships accompanying those needs will be multiplied and prolonged, and a fundamental failure in our justice system will be correspondingly enlarged. That is a failure which we lawyers will not countenance, and this is an opportunity we will not miss. Thank you very much. At this time, as has been the custom for the past few years, we honor a very special group of people. We hear a great deal about the service which lawyers render and which judges render, but we all know that one of the most important components of a justice system is that large group of people we call the non-judicial personnel. They are the heart and the sinew and the backbone of our court system. And so this year, again, we have the Merit Performance Awards presentation, and I will turn this over to Matthew T. Crossan, who has served so well over this past period as the Chief Administrator of the courts. Mr. Crossan.
Judge Wachtler, Associate Judges of the Court, Attorney General Abrams, President Yanas, ladies and gentlemen. The spirit of uncommon dedication and willingness to do more than duty requires sets public servants apart from others. It is a spirit largely measured by concern, tolerance, and understanding of our fellow human beings. And it is a spirit that is prospering in our state's court system. To honor that spirit, the judicial branch has again chosen to present today its Merit Performance Awards for non-judicial employees. There are 3 awards, 1 for heroism and 2 for outstanding work performance, 1 to be presented posthumously. On behalf of the recipients and all those others in service whom they represent, I thank Chief Judge Wachtler and the Associate Judges of the Court of Appeals for allowing these presentations to be made part of the Court of Appeals Law Day program. I would ask that Senior Court Officer Donald Simeone please come forward. Hundreds of thousands of New Yorkers ride the subways in New York City each day, and for them, fear of crime is a constant presence. Few things are as terrifying in the closed confines of a subway car as an assault by a large group of criminals, what has come to be called a wolf pack. On the morning of November 9th, 1988, Senior Court Officer Donald Simeone was, as usual, riding the F train on his way to work at the Supreme Court in Brooklyn. Suddenly, a group of 10 to 15 youths entered Officer Simeone's car and attacked the man at random, punching, kicking, and ramming the man's head against and then through the train's window. Without hesitating, Officer Simeone confronted the attackers, and leaving his gun holstered so as not to endanger the other passengers, he nevertheless single-handedly stopped the assault and managed to arrest 3 of the assailants. Because of Officer Simeone's swift and decisive action, the victim was spared serious injury. For this act of exemplary and selfless courage, we present to Senior Court Officer Donald Simeone a Merit Performance Award. I would ask that Principal Court Clerk Angelo Tropea please come forward. For many people in New York City, the quality of justice is measured not in the handling of sensational trials, but in the handling of the lesser-known cases that come before the small claims court and the housing court. In those courts, truly the people's courts, where New Yorkers often speak for themselves, the demand for fundamental justice is strong, immediate, and passionate. Channeling that passion so that justice can be done is the task Principal Court Clerk Angelo Tropea has undertaken in Brooklyn in recent years. No one does it better. As supervisor of the Small Claims Clerk's Office a few years ago, Mr. Tropea brought order to a hectic and chaotic environment. He is a man of singular initiative. Asked to prepare a checklist for use by small claims clerks, he produced a 200-page comprehensive small claims manual that shortly will go into general circulation. When he became supervisor of the Brooklyn Housing Court Clerk's office, he put on overalls, cleaned out 2 old storage rooms, retrieved some discarded countertops, used them to establish a new order to show cause window, and thereby reorganized, simplified, and speeded up the flow of people and business in one of our most crowded and hectic courts. Angelo Tropea leads by example, always instilling in his colleagues a sense of the importance of their work. For his exceptional initiative, dedication, and commitment to excellence, we present Principal Court Clerk Angelo Tropea a Merit Performance Award. I would ask that Verna Dallway and Elizabeth Garland please come forward. In every large institution, like New York's court system, there are people who, by their concern and understanding for others, give life to the workplace. And there are a few people of rare character whose exceptional caring can renew the spark of life in friends and colleagues worn down by the burden of daily living. Senior Court Officer John A. Dallway, Jr. was such a man. John Dallway spent his life helping other people. He was known for his kindness, his smile, and his easy gait. For him, every one of life's problems could be solved if only people worked at it. When the court system created its employee assistance program a few years ago, John Dallway was the natural choice to organize it where he worked in Brooklyn. Helping others then became John Dallway's job, and at that he excelled. In 2.5 years, he made more referrals of those in need to drug, alcohol, and other programs than anyone else in the state. Because of his efforts, many people were successfully rehabilitated, given back the fullness of their lives. On the morning of October 3rd, 1989, while on his way to visit another colleague in need of help, John Dallway was struck by an object falling from a building scaffold. He died instantly. But the good he did, the spark of life he gave to those he touched, will live on in those who knew him, passed from one helping hand to the next. For a lifetime of extraordinary service to his colleagues, his neighbors, and to the court system he loved, we present to Senior Court Officer John A. Dallway, Jr. a Merit Performance Award, and we ask his wife, Verna, and his mother, Elizabeth Garland, to accept it in his memory.
Thank you very much, Mr. Crossan. And I thank all of you again very much for being with us during these ceremonies. And now, as is customary, the judges of the court will step from the bench and greet all of you that we can. And again, it was a delight to have your company. Thank you.